Welcome to Silberman Law Firm's Weekly Docket, episode 31, where we talk legal news and practical law. Today is August 15th, 2024, and I'm Phil Silberman, owner of the firm and your host. Austin Black is my co-host, and he also works in our Dallas office. How are you doing today, Austin?
I am doing great. How about yourself?
I'm doing pretty well. I'm back in Texas. I'm just blown away by the heat.
Yes, I'm so glad you're here to experience this now and not in your ivory castle of the cool weather.
My kids still go to school here, so I have to come back. But it is beautiful here in the wintertime. And just these are our worst months of the year. What do we have on our docket today, Mr. Black?
So first, we're going to go for our legal news section as per usual. The beginning story we're going to be talking about is how a CrossFit Games athlete drowned during an event in Fort Worth, Texas. That may not sound like a legal situation, but we'll be talking about potential lawsuits involved in that. And then we will be discussing Meta, or what Facebook became, settling a lawsuit from the state of Texas regarding facial recognition software that was running automatically on Instagram. And this is something that's been going on for a long time, and they just reached a settlement for $1.4 billion. Now, are you ever going to see that? We'll let you know. Then the legal question section of our show today. First, we're going to be talking about if Phil is coming outside of my apartment every day and banging on my door and I want him to go away, how is a restraining order handled? Okay. That's the first thing we're going to be talking about, legal questions. And then second, if my girlfriend, who is a doctor, does something very bad, how can you sue her? Okay. How do you sue doctors in Texas? We'll be talking about that too. And finally, our rant and rave section will be discussing how California recently had a ruling that secured independent contractor status for Lyft and Uber drivers. Now, is that good that it secures independent contractor status for them, or do they want to be employees? We'll talk a little bit about that and let you know our thoughts.
Yeah, no, if I'm in reference to your comment about me beating on your door and perhaps you need to get a TRO. If I were beating on your door, it would be to get you to bill more hours. I want you to know that. That would be that'd be my whole.
I think every judge would grant that TRO.
Probably. I don't know how sympathetic judges are to the billable hour requirement that attorneys are for profitability.
Probably not much. That's why they're judges, right?
Right. But we can't say anything. Let's not say anything bad against judges.
Oh, no, we love judges. We love judges.
All right, let's get started with our legal news section, which is this CrossFit Games thing. And so there was a CrossFit Games event going on in Fort Worth, and tragic accident. In the middle of the event, there was a gentleman, I'm going to mispronounce it, but Lazar Ducic, who was from Serbia. He's participating in this CrossFit event. It included a 3.5-mile run followed by an 800-meter swim. And in the middle of swimming, you could see that he was in trouble. And the other swimmers, I heard the other swimmers, it looks like he's in distress. And tragically, he drowned in the middle of the event. So horrible thing that happened in Fort Worth up near where you are, Austin. So I don't know where they were swimming, but somewhere, some lake or whatnot. And, he was the third, he was pretty good at this sport. Third-ranked CrossFit athlete in Serbia, 88th ranked worldwide. So this guy was a legitimate athlete. He was a brother, he's a son. He was married. Wife is Dr. Anja Pottervit. His brother posted on his Instagram story after the death, "You love the sport that didn't love you back. No tribute will ever give you back to me." And the brother says this is something that could have been prevented and there is no way of going around it. A little bit of a loaded kind of comment there. I think the brother seems to feel pretty strongly that the event could have done something about this. And we don't have all the facts on that. But brother, obviously, heartfelt post there with some implications that maybe the event had some liability. So, Austin, anytime you do these events, and I don't know how many CrossFit events you participate in, but when you go do this event, you have to sign a waiver.
Yeah.
And the waiver says you assume of all this risk. Yeah. And the person who passed away here, Luka Ducic, he obviously signed a waiver. Now, What are your kind of thoughts on that? If he signed this waiver with an assumption of risk, is the event clear of all liability, Austin? Do you have any kind of initial thoughts on that?
No, not all liability. It doesn't normally shield them from things like gross negligence. Like, for instance, let's say one of the organizers was like driving a truck full of piranhas and that dumped in the lake, right, when they're swimming. That would be grossly negligent, right? And they let them swim, then that would not shield them from any liability from that. But normal things that are occurring, usually it would shield them from something like that. For instance, just a more common situation where people get hurt, like combat sports. If in the course of the combat sport, you get hurt just from normal things there, yeah, that's not going to be a problem. But if for some reason they don't check a competitor or something, or they have a knife and they stab someone, that's obviously not the normal situation in the combat sport, and someone could be held liable for their gross negligence there. So
Okay. So you do taekwondo or jiu-jitsu or something, Austin? Did you tell me?
I did a little bit of taekwondo, but that was not serious. Fencing is the combat sport I did the most, and an example of a lack of an assumption of risk or gross negligence in fencing would be if a referee, someone employed by, say, the Federation International of Fencing, sees that one fencer has a broken blade, and they tell them to keep fencing, and someone gets stabbed. That's the only way that the blade can actually go through on the protective fabric is if it's broken at the top, and it goes through someone's body. Then that would be gross negligence because they saw that it was broken, or they saw that it was bending in a wrong way, and they allowed it to continue.
Yeah. In this case, you know, he obviously signed a waiver. He was swimming. If he's just maybe in the water and has a sudden heart attack, or maybe during the running portion, he twists an ankle, that's something that through the waiver, you assume the risk. The state of Texas recognizes an assumption of risk doctrine, right?
Yes.
It's like when you live on a golf course and you have balls going through your windows all the time, you're assuming the risk of living on a golf course.
I apologize to anyone who lives on any golf course on which I have golfed, because I guarantee you have known it.
But there are certain standards that also talking about gross negligence. I think an example that maybe hits home to more commonly to a lot of our viewers. If you're a parent out there, you take your kids to trampoline parks. If you take a kid to trampoline park, you sign a waiver doctrine, your kid goes in there, jumps, breaks an arm. That's likely not on the trampoline park. Okay. You're assuming that risk. That kind of thing happens on trampolines.
Yeah.
But you go in there, kid jumps, falls through a trampoline because the trampoline's faulty and no one inspected the trampoline. That waiver then no longer protects the trampoline park. So these are the things, the differences we're talking about. So Texas does recognize these waivers. We've represented a lot of small businesses that when we've drafted these types of waivers for trampoline parks, for amusement parks, for different kinds of facilities, hunting, in Texas, we do a lot of hunting. If you got a bunch of guys coming on the property and they're doing hunting for a lease or something like that's a good type of waiver to have. Or if you're offering your property up for Boy Scouts to go camp on it, you're going to want to have a waiver. Those waivers do protect certain things. We do recognize assumption of risk in Texas, but it's not a get out of jail free card for being negligent, for really doing something. So I think that's the crux here. We do have some cases, Smith v. Golden Triangle, again, Texas rule recognizing gross negligence overrides a signed waiver. That was a racetrack deal. So the plaintiff was injured at a racetrack who signed a waiver. So you got Dixon v. Houston Swim Club. That's actually very relatable, appropriate to this case because the CrossFit athlete died during swimming. You got to have safety measures. Just because they signed a waiver doesn't mean they're gonna be absolved of liability. So if you're running these events, you have to be careful. And if you're in this type of business, CrossFit events, if you're racetracks, swimming pools, these are inherently risky activities.
Yes.
So you can't just have your people sign waivers and forget about it. You need to stay on top of your game when it comes to this type of stuff. So anyway, super sad that there was a death there in that event right in Fort Worth here in our home state. But I do think there's going to be a lawsuit that arises out of that, and we'll keep everyone updated as that lawsuit comes in, likely by the athlete's family. Right. All right, let's move on to our next legal news piece, which you've got Meta settling the Texas facial recognition case. Meta was sued by the state of Texas, had collected data that violates privacy laws on Facebook, presumably, or Instagram. Everyone takes photos, uploads photos, and Meta's using that data.
And it was used specifically for an auto tagging system, right? Where they didn't actually tell you that this was what was happening, that they were pulling your facial recognition data and using it to like auto tag you in photos, whether or not you agreed to it or not. Just crazy. So
yeah. I think I was auto tagged.
I was too. I had to go remove tags. I was like, there's a reason I didn't tag myself in this photo. Okay.
Is that so? You were photographed doing something you should not have been doing?
No, not photographed doing something I should not have been doing. Just a less than flattering photo, of which there are many of me. And so I don't want that tagged. This is a pretty normal thing. And Facebook's, hey, let me tag that. No.
So it wasn't a photo of you doing anything scandalous.
No.
You just thought you looked a little fat or something.
There are no photos of me doing anything scandalous anywhere.
Yeah, let that be a lesson to all of our young people. If you want to keep yourself hireable and be able to get future jobs or keep your current job, like you don't want to photograph yourself doing anything crazy or video yourself doing anything crazy. So,
good idea.
I did not know this, but in Texas, we have something called this Texas Biometric Identifier Law. And it's the Texas Capture or Use of Biometric Identifier Act. It's QB Act for short. Enacted in 2001, prohibits companies from capturing or using biometric identifiers, including facial geometry, without informed consent from the individual. So this is codified in Texas Business and Commerce Code, section 503.001B, and you have to get consent. So I guess Meta, in this case, Facebook, Instagram, did not get our consent when they started auto-tagging us, Austin.
No, they did not.
The biggest lawsuit, Meta agreed to pay $1.4 billion, that's billion with a B, to settle over 5 years to settle that. Biggest settlement attained by any single state. That just really shows you how everything's bigger in Texas. Exactly. We popped Meta pretty good on that one. So this kind of did get me thinking about some of the crazy stuff that China does, though. Are you familiar with all the facial recognition stuff that the Communist Party does over in China?
I am.
I mean, I saw some news articles on it. Basically, anytime you're walking about China, you just assume that you're being videoed.
Your social credit is being deducted heavily at the moment.
Why is that?
Because you're talking. It's not a bad thing. So if you're not doing anything bad, you have nothing to hide, right?
Oh, is that what it is? Okay, I see. It's like the cop tells you don't have anything to worry about. If you didn't do anything wrong.
Yeah.
Yeah, I'm not. I don't subscribe to that type of theory. The craziest thing that I saw come out of China is that they equipped Chinese police officers with these smart helmets, and it's a very futuristic thing. Like the Chinese have the smart helmet on, and the Chinese police officer has a smart helmet on, and he's going around just in the general masses of China, and the helmet is like automatically feeding him data. I don't know if the sensors are going to a central location or if he has some kind of visor where he can read the data. But during COVID, for example, he'd have the smart helmet on and he was just taking people's readings, temperature readings.
Yeah.
They would also use, I guess if the guy was fighting crime or looking for somebody, he would just, if he saw somebody who was wanted or whatever, they would just get him and disappear him. That's how it works.
Taiyuan, I don't know if I'm pronouncing that correctly, but Taiyuan, China is the most surveilled city in the entire world and has 117 cameras per 1,000 inhabitants.
117 cameras per 1,000 inhabitants. Yeah. That's like basically one camera for every 10 people.
Yes. Yeah. More.
Those speeding cameras is what drives me crazy.
Oh, absolutely.
The French, I like France a lot. I like France a lot better than China. They tried to put speeding cameras up in France and the French took to the streets and blocked the streets and tore the cameras down.
Yeah, the French, if they're good at one thing, they're good at protesting.
What republic are they on now? Is it like the 5th or 6th Republic of France?
I'm pretty sure it's the 5th.
It's something crazy.
5th or 6th, yeah.
All right. Meta gets tagged pretty good. billion or whatever it is for all that facial recognition they did in Texas. But let's go on and answer some legal questions. Okay. So the first question we have is, how are restraining orders handled in Texas? So this was where Austin was talking about people that are harassing them. Have you ever been stalked or harassed before, Austin? Think about it.
Yes, I've been harassed before. A very uncomfortable situation with some woman making, like in her late 50s, making very uncomfortable advances and like attempting to touch me on a public bus in Austin.
Really?
Yeah. It was one of the most uncomfortable experiences of my life. So I can't even imagine what like women who deal with that stuff so much more often.
Was she an attractive 50-year-old lady?
No. And I wouldn't have cared if she was. It was violating. She I moved my seat and she got up and followed me and sat next to me again. And I got off the bus at the bus stop. No one did anything about it. They all saw. And I got off the bus and walked 2 miles home.
How old were you? This was recently?
Oh, no, this is when I was in law school.
Oh, you're in law school. Okay. I'm a little more sympathetic if you're in law school.
It's inappropriate for anyone. I like that's like people look at that sort of a thing when it happens to a male and they treat it differently than when it happens to a woman. And it's just not. Like it happens less often to men. And people ask things like what you said. I know it was jokingly, right? Was she attractive? But it's not okay either way, right? And it felt very bad at the time. And for no one to even do anything about it who saw that happening was crazy. But
I do agree with you. It's wrong either way.
Yeah.
But you're not going to get a lot of sympathy, I think, as a man.
No.
Yeah.
Yeah.
It'd be an interesting question if our listeners are more sympathetic about it or not. I think you handled it appropriately. I guess you got some exercise in the 2-mile
Yeah.
walk.
If she had followed me home, what could I have done? That's what we're talking about now, right? A restraining order, it's a legal document that's issued by a court to protect an individual from being harmed, harassed, or threatened by another person. It can impose legal restrictions on the behavior of the person against whom it's issued to ensure the safety of the protected individual or individuals. So, yeah, there are 3 different types of them. There's a protective order, which is usually used for family violence, stalking, or sexual assault. So that's probably the one you hear about the most. A TRO, or temporary restraining order, is used in civil disputes. And that should be used solely to maintain the status quo. And you need to show a court that you're likely to succeed on the merits of the case at the end in order to get that TRO granted. And then there's also stalking/cyber stalking orders, which are a more recent development.
Now, the type of restraining order that you hear about in the media all the time is the one where they're being stalked or it's a family member, right?
Yes.
Those are the more common ones. Now, the ones we deal with as civil lawyers are typically arise out of a lawsuit where people are fighting over money. So have you done any TRO hearings before?
I have both defended TROs and gotten them granted. Yep.
So the way that works in Texas is you have to, let's say you've got some irreparable harm that's been done to you or your business. Okay. So the idea generally, you typically see them at non-compete agreements. You're an employer, you had an employee sign a non-compete, and that non-compete is being violated, and that employee is working. The employer will often file a petition for breach of the non-compete agreement, and that petition will have an application for a TRO, temporary restraining order, and you go down to the court after filing the petition. And you typically get a judge who's not necessarily assigned to your case ultimately. He's just the judge that's assigned to hearing the TROs for the day. And you have to show that there's irreparable harm being done to get that TRO. And typically, you have to show that money's not enough. Because if you just have a breach of contract and you can solve it with money, if you win, you're going to get money. That's not the type of thing that's going to be available.
Yes.
And it usually is an ex parte hearing, which Austin, tell our listeners what ex parte is. What that
it's a hearing with just one party, not the other party, and that's so that's for the temporary restraining order. When a temporary restraining order is granted, and sometimes judges grant temporary restraining orders. Usually, those are categorized as emergency restraining orders, emergency temporary restraining orders. Those will sometimes be granted even without a hearing if you can show enough in the petition for it that the judge believes that it's warranted. But whether an emergency or a temporary restraining order is granted, there will then be set a hearing for a permanent permanent restraining order or an injunction or TI, temporary injunction, something like that. The hearing for the temporary injunction, usually you're asking the judge to put in place similar restrictions to the temporary measure that was already in place up until the point of the trial, at which time you would ask for a permanent injunction if you needed one. But in cases where there are restraining orders like this, the TI hearing, the temporary injunction hearing to determine if an injunction is going to be in place until trial, is usually where the case is won or lost. Because at that time, you're presenting everything you have, and the judge is going to make their decision on whether they believe that you're likely to succeed on the merits. And usually whether someone wins or loses at that point is when people start trying to settle.
So you get, to summarize it, you file your petition, you go down to the court, you tell the judge, hey, this is urgent, I'm going to be harmed, grant this restraining order. Let's just say it's non-compete, keep the employee from working. If the judge grants it, and by the way, typically you got to post a bond, but if the judge grants it, then about 3 weeks later, you're going to have the TI, the temporary injunction, and then you have a little mini trial. And if the judge grants it again, then that's going to stay in place until it's resolved on the merits. That's how that works. That's the type of restraining orders we deal with in the civil courtroom. Those other types of restraining orders where you're in a family law court or some other type of court for criminal matters, that's different. But those are the type of restraining orders. Those are the most common types in Texas. That's all about restraining orders. And our next legal question is just generally about suing doctors.
Yeah. So
Austin,
we are going to restrain ourselves from going further on the topic of restraining orders.
We are.
But we release ourselves when it comes to suing doctors. Yes. So.
Yeah, but we don't really know a lot about suing doctors because we don't do it.
We don't do it.
But we're going to talk about it because we get a lot of calls, and it's just the general public wants to know.
Yeah.
It's interesting. If you have a doctor, you think you were misdiagnosed, you think the doctor didn't provide the right standard of care, you can sue the doctor for medical malpractice. It all arises out of a negligence suit. Anytime you're suing professionals, it's going to be negligence based. So if you sue an attorney, the idea is the doctor breached the standard of care. They did something that, no other reasonable or competent doctor or lawyer would have done. And we've talked about negligence on this show a lot, but real quickly, Austin, give us the elements of negligence one more time.
Negligence, you need to have a duty of care to someone. You need to breach that duty of care, and then that needs to cause damages to the person.
Now, suing doctors used to be really big business, okay? They were entire plaintiffs' law firms dedicated to medical malpractice in Texas. Because there was a lot of, it's not like the defense attorneys, the guys who were defending doctors, it's not like they exactly hated the plaintiffs' lawyers because the plaintiffs' lawyers were keeping them in business on the billable hours. You had these gigantic sections of big law firms that were dedicated to defending malpractice lawsuits. And then along came tort reform in 2003, but it's Tort Reform Act House Bill 4. And that placed a cap on non-economic damages. And that was a big deal because you can now only get $250,000 in punitives, right?
Yeah.
So why is that a big deal? It's $250,000. If a doctor does something wrong, Austin, does $250,000 seem like plenty of money to punish the doctor?
No, it doesn't. Considering the starting salaries for a lot of doctors is around $300K. No, it doesn't sound like that.
All right. Well, so you're anti-tort reform. You think that you ought to be able to pop a doctor for a big number.
I see the public policy concerns on preventing, because if they could be hit with high damages for a medical malpractice claim, then there's a possibility they wouldn't do or attempt procedures that would otherwise be the best for attempting to help the patient. So I see both sides, and pain and suffering damages are also a little bit sketchy to me sometimes. But I think in situations where it is medical malpractice like that, those are the most appropriate pain and suffering ones. Not situations where someone is suing their HOA and they call me and they say they want pain and suffering for the mental anguish that dealing with their HOA has given them. I'm sorry, that's usually not going to fly.
Yeah. There was a lot to this tort reform stuff. It included the cap on non-economic damages. It included some prerequisites to filing a lawsuit. You now have to have basically a report or an opinion from a professional, and someone in that field prior to filing the lawsuit. That's a condition precedent to the suit. And if you don't get that report, you're automatically tossed out.
Well,
So
not only are you automatically tossed out, right? If you've already filed it, right, and you don't submit that report within a certain amount of days, then you not only have your lawsuit tossed out, but all costs and the doctor's attorney's fees are assessed against you.
And it's tossed out with tossed out with prejudice.
With prejudice,
So
you cannot bring the claim anymore. Yes.
So tort reform is pretty significant in Texas. And the cost of malpractice insurance, I don't know what the exact number was, but it was crazy. It was like if a doctor was paying $30,000 a year for malpractice insurance, after tort reform, that number went down to $5,000. And the real problem economically is that you're a patient and you had a doctor misdiagnose you, or you had a doctor not do the right thing or commit medical malpractice. The real problem is the cost of working up that case against the doctor, because you have to have experts. You have to have another doctor testify that the doctor deviated from, a standard of care is expensive. So you're going to spend at least $50,000 to $100,000 to work up that case. So if you're looking at a cap of $250,000 on non-economic damages, that's tough. Now, what cases still work? If you're a doctor and you're listening to the show, you really only want to provide services to poor people that are not high income earners, right? Because if you mess up something on a high income earner, right, then that's an economic damage. If you're doing hand surgery on the world's most famous violinist or pianist that gets paid millions of dollars for concerts, and you mess up their hands, those are economic damages. So those are not capped at $250,000. You follow me, Austin?
Mm-hmm. I do.
So if you're a doctor, you want to operate or provide care to people that are high income earners. That's really, I think, the take home from this.
So in other words, go work at Parkland Hospital.
Is this the hospital where JFK was cared for?
Yes.
Okay. Well, this has come up in the show before. Yeah. Go work. I don't know how much money you make working at Parkland or some of these poor hospitals, but and obviously I'm joking, right? You
make around $70,000 a year.
No, I don't believe that.
Oh, yes. As a resident, you do.
maybe as a resident, but that's tort reform in Texas. It really eliminated entire defense departments or defense sections at these big firms just went belly up overnight. If you're looking to find a lawyer to sue for medical malpractice, it's much, much more difficult. We don't do that. Please don't call us. Sometimes we do probate work for attorneys that are doing medical malpractice lawsuits, but it's hard to find a medical malpractice lawyer now because there's a lot less lawsuits against doctors. There's also a lot less attorneys defending those types of lawsuits. So limitations periods, how long do you have to sue a doctor? 2 years. Negligence is a tort, is 2 years statute of limitations. That's not very lucrative to sue doctors anymore. Plaintiffs' attorneys had to get on to something else. And what did they jump onto, Austin, after tort reform? We talked about this in previous shows as well. They all jumped onto the FLSA, the Fair Labor Standards Act. A lot of plaintiffs. And that brings us to our rant and rave section, which is my favorite part of the show. But we're talking about the state of California got a ruling that basically said all those Uber drivers out there, all those Lyft drivers, you are solidly and squarely independent contractors. Now, you probably never thought about whether you're Uber or Lyft driver is.
Actually, I have thought very much about this. And you want to know why I've thought a lot about this?
Why?
Is because in your first year of law school, you have a legal writing class. And for that class, you typically have a final draft. You need to produce a petition or an argument or a motion for summary judgment, some sort of thing, legal filing. And the problem that mine was over that I was writing a brief on was independent contractors and for a Lyft or Uber service. So I've actually done a lot of research on this in Texas. So yeah.
Okay. So you're familiar with the concept of misclassification.
I am.
Okay. So that's what this case was about. It's a misclassification deal under the FLSA. Now, The California angle on this, and before I move on, by misclassification, generally the idea is if you're a plaintiff's attorney, you find an Uber driver, you form a collective action, you sue Uber for violations of the FLSA saying that they were misclassified. And because they were misclassified, they worked overtime and they weren't paid minimum wage or whatever. And you sue them under the statute called the Fair Labor Standards Act. There's also tax consequences. The federal government and the local government, state government, they benefit from these drivers being classified as employees because they get to collect the employment taxes on them. So that's typically why the government generally wants these people classified as independent contractors. The government will say, oh, we want them to be safe. We want fair working conditions and all that. But I think what they really want is more tax. This is the special kind of crazy, though, that really upsets me about the state of California. The Uber and Lyft drivers started a petition to get Proposition 22 on the ballot. And Proposition 22 basically said, we, the people of California, want to vote on whether or not our Uber and Lyft drivers specifically can be contract. And it went up to a vote, and the people decided that we want Uber and Lyft drivers should be classified as independent contractors. And that's it. We don't care. They want to be independent contractors. We want them to be independent contractors. This is how crazy the state of California is. The state of California said, screw the people of California. We're going to challenge the constitutionality or the validity of Proposition 22 that the will of the people voted on. And we're going to take that to this California Supreme Court. And we're going to see if we can just undo that, the will of the voter.
And the labor union, labor unions do stupid stuff like that all the time. But the fact that the state was involved in this and spending taxpayer money on bringing this challenge that the taxpayers had already voted for is insane.
The crazy Republic of California. So goes up to the California Supreme Court. California Supreme Court affirms the ballot, says no. I mean, Proposition 22 passes, nothing unconstitutional about it. And there you have it. You can now be an independent contractor, Uber and Lyft driver, or DoorDash driver. DoorDash and Uber and Lyft are touting it as a huge victory. And by the way, the companies are not innocent in this either, because the companies are saying, oh, we respect the fact that an Uber driver may only want to work a couple hours and we want them to be flexible. Look, don't go believing that these companies have totally altruistic value systems either, because they really just don't want to pay the taxes either.
Absolutely.
They want to avoid the state and federal employment taxes. So it's not like those guys are innocent either. But I'm a big free market guy. I think if you're an Uber driver and you want to be an Uber driver, I've heard that driving Uber is pretty much no better than $10, $15 an hour. I don't know if that's true or not. I've heard it can get even worse when you factor in gas and depreciation on your car. And then I've heard that a lot of people driving for DoorDash actually lose money. They just don't realize it. I don't know if that's true or not. But that brings our show to a close. I've been your host, Phil Silberman. Austin Black has been my co-host. Like us, follow us wherever you get your podcast. As a reminder, nothing in this show is to be considered legal advice, and this is all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com, info@silblawfirm.com. Tell us you want us to answer it publicly in the podcast. We will do our best.
And we have never had that request once in the history of doing this show. This is the 31st episode, and we have not once had someone email us saying they wanted a question answered in the show. Now, do I think it's because none of you have questions? No. I think it's because all of you are embarrassed about your legal question. Don't be embarrassed. Send the question. We'd be happy to answer it. We will answer it and not name who asked it, okay?
Well, what they do, though, is we get hundreds, if not thousands of questions on the social media platforms. So they go on YouTube or whatever, and when we do the shorts, they ask the question.
Or they tell us what they think the answer is, right?
Yes, that works. That works too. All right, everybody, have a great rest of your week.
Bye.
Bye.